Hi, I'm Peter Afrasiabi. The program you're about to watch, IP Overview for the Non-IP Lawyer, a copyright, trademark, patent, and trade secret survey, was recorded a few years ago, but I've confirmed the content is still current and timely and reflects the current state of the law. I hope you enjoy it. Hello, my name is Peter Afrasiabi. I'm a partner with One LLP, an intellectual property boutique with offices in Newport Beach, Beverly Hills, and Del Mar, California. The views expressed in this MCLE program are only mine, so blame only me if you don't like them. Today we're going to do an overview of intellectual property law for the non-IP lawyer, and let me stand and deliver right now on this to you. If you are not an IP lawyer, you're a general practitioner, and you're sitting here thinking that IP law has nothing to do with you, you're wrong. What you're going to see at the end of this survey is that the four major pillars to IP law, we can think of them almost as four legs to a chair, and those are copyright, trademark, patent, and trade secret. They cut through all areas of law, and they are interfacing with you and your clients in ways that you may not realize all the time. And some of their principles are counterintuitive, and they really run against the grain of what is the sort of the norm in terms of tort law and property law and even contract law in terms of who has rights to what. So let's get started. The first area of intellectual property law we're going to talk about is copyright. The question you're asking is, what is copyright? You know, what's a copyright? What's a trademark? What's a patent? What's a trade secret? How are they all different? Well, a copyright is at a minimum just that, the right to copy. Now, it's far more than the right to make copies, as we'll talk about shortly, but at a minimum it is the right to copy. So what kind of things does copyright inhere in? Well, copyright exists in, as this first slide shows you, original works of expression that are fixed in a tangible medium. And so you see on this slide we have some pictures of a Van Gogh painting, his self-portrait, there's a little sculpture, and there's another painting. All of those things are the types of things that copyright exists in. They are original works fixed in a tangible medium. So let's unpackage that briefly. If we go to the next slide, we can see the full scope of the things that fall within copyright's realm. And so this is where it's very important to you. Some of them are obvious, and those are sort of books and other writings, music, film, photographs, works of art, right? Everyone kind of knows copyright's in that. But copyright's in much more than that. It's also in software and source code. So if you have clients that are writing software, maybe they're creating an app for someone for the iPhone store or the iTunes store, they're dealing in trafficking in copyrighted works. They may not know it, you may not know it. Architectural works, those have copyright protection also. Even clothing designs trigger copyright law and a lot of copyright litigation over the designs in clothes. And of course, pantomimes, choreographs. So that's a sort of nuts and bolts list of the types of things and the types of media in which copyright will inhere. Other areas of intellectual property law will inhere them too, as you'll see, but those kind of give you an overview. So let's unpackage now the first requirement, and that is originality. It's got to be an original work of authorship, remember? What this means, as you see on the next slide, is that it's original to the source. That means the creator, the author of it, originated it, him or herself, in the first instance. Now, it may be that I truly, independently write a poem that is literally identical to another person's poem that's been around for 100 years. And if I genuinely wrote that poem without ever having seen or heard or known the other poem, I just happen to land on the exact same grouping of words, I'd have a copyright in it. It is original to the author, that is the requirement. Now, courts do not want to get embroiled in the merits of how strong one's art or work product is. And so the result has been that the Supreme Court has long held that there's really a low threshold for this minimal level of creativity. And it really is a minimal level. If right now you're listening to this program and you're doodling a nice cool little picture on the pad of paper as you're listening to me speak, that doodle, you have a copyright in that doodle. You've already got it. You see, you've already earned a copyright, and we're only 5 minutes into this MCLE. Now, maybe you're strumming along on a guitar, and you've hit 8 new notes that are really, really cool and special. I'm going to tell you in a second whether you have yet a copyright in that, and you don't quite. but keep strumming the guitar. So let's go to the next slide. This is a statement from Justice Holmes in a famous case from the turn of the last century called Blystein, where he says, "It would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worth of pictorial illustrations outside of the narrowest and most obvious limits. At one extreme, some works of genius would be sure to miss appreciation. At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge." This is the underlying policy, and it's still in full force and effect today in 2016. Courts do not like to be making artistic value judgments about whether something is sufficiently original to warrant copyright protection. So your boring little doodle of a bunch of flowers and shapes, it has sufficient minimal creativity to warrant copyright protection. This gets us to the guitar notes that you're playing. And this is the second element, and that is fixation. Fixed in a tangible medium of expression. Those are sort of complicated gobbledygook words from the US Code, which basically simply mean, has something been permanently recorded? So, did you take pen to paper? Those of you who are doodling have been taking pen to paper, and you have now fixed in a tangible medium on the piece of paper with the ink your copyrighted work. If you're strumming the guitar and you've hit 8 really cool new notes, you haven't yet permanently recorded it. So what you need to do is get out your tape recorder and record yourself playing those 8 notes, at which point you have now created a sound recording of your musical composition and you've got a copyright in it right now. Or write the notes on music and you've created your sheet music and you've got a copyright in it that way. Source code is another example. It has been held, and the Congress has made clear, and the statutes and the case law has made clear, that once code is written in a computer and it's saved on the hard drive, boom, it's been permanently recorded and it's fixed in a tangible medium. Now, what's an example of something that is not, as well as those of you who are riffing on your guitar? Maybe you come up with the greatest "I want to marry you" slogan imaginable, and you pay one of those airplanes that fly up and they do smoke skydiving or smoke in the sky stuff to paint the poem for your loved one. That incredible poem of yours that's sitting in smoke in the sky has not been reduced to a fixed tangible medium in a permanent fashion. So you don't yet have a copyright, and you've shared with the world your incredible poem. The next slide is a perfect example of the type of business really that you may represent as a general practitioner. And this is where copyright starts cutting across you and your practice. If you help small businesses, solo shops, sole proprietorships, small LLCs, companies that are just creating maybe management training materials or how-to manuals, or they're out there creating sort of better ways to sell soccer materials to soccer players, whatever the small business may be, they are trafficking in copyrighted materials, and it's very important to have a general understanding of the lay of the land so you can protect them. This case, Kepner, is an example of one such company dealing with, software expressions of certain kinds of business models, leadership questions, problem attributes to improve management decision making, types of flowcharts that businesses often create. Copyright, believe it or not, inheres in that. Now, this gets to an important line in copyright, and that is the idea expression line. Copyright doesn't allow you to monopolize ideas. You have protection by copyright in your expression of that idea. So, the famous example, Einstein's E equals mc squared, this idea of relativity, which we're certainly not going to talk about today. That idea of relativity is an idea. It's a mathematical formula. He doesn't own a copyright in it just because he came up with E equals mc squared. Now, the paper he wrote explaining his theory of relativity on the theory of electrodynamics, or whatever the paper was called, that paper, he has a copyright in that expression of the idea. So, history, the facts of the history, the American Revolution, the Declaration of Independence, the War of 1812, World War II, etc., etc. The facts are not subject to copyright. But one history book writer's rendition of those facts is entitled to copyright protection, which means their express, specific embodiment of those facts, they have a copyright in. When does copyright exist? This gets at some of the myths that are out there about copyright law. Today, copyright exists the moment you fix in a tangible medium your expression. So your doodle that you wrote, you have a copyright in it today, right now, this second. There is no formal registration requirement to secure a copyright, and this is one of the misnomers that exists in copyright law. You don't have to register anything to have a copyright because you simply have it by virtue of authoring it and recording it in a fixed form. Now, there are massive benefits to registering, huge benefits, and I'm going to give you some examples of the difference between artists and small businesses who create genuine, legitimate copyrighted works and the difference between when they can protect them in the law and the legal system and when they can in our court system. Registration is often the difference between being able to protect them. If you register your copyright before it is infringed or within 90 days of publication of the copyright, even if infringement maybe occurs instantly upon publication, you can recover statutory damages and attorney's fees. And statutory damages are decoupled from actual damages. They're up to $150,000 if the work is infringed, if it's willful, up to $30,000 if it's not willful, and a minimum of $750. So your incredible doodle that you're making right now, not only have you already earned a copyright, if you register it with the Copyright Office and I go and steal it in my next presentation I do, I'm going to owe you at a minimum $750. Now what this means for small businesses, you take a classic example of the type of company I represent are small photographers and photo agencies. They take photographs all the time. The market value of a given photograph may be relatively small, $50, $100, $500, but they register their photographs. And if those photographs are infringed, and infringement occurs far more today than it did even 20 years ago because of the internet, which facilitates the mass cut and paste, function of content. If they've registered those photographs with the Copyright Office, when they're infringed, that infringer now can be subjected to real penalties and having to pay attorney's fees. That enables your small content creator, your small business who can't afford to pay a lawyer the hourly rate to access the court system to find a law firm to take it on contingency. And law firms take these on contingency, and then they can go to the court system and get redress for the wrong. If it's not registered timely and it's infringed, when you go to hire the lawyer says, I can't get you statutory damages or attorney's fees, so there is no sort of contingent upside for the firm. You have to pay hourly, and the artist looks at it and says, but it would cost more than I would ever even get back in damages, so therefore I have no access to the court system. Even if I can afford legal fees, it doesn't make economic sense, and the work goes infringed, and the author's work is not protected. So, huge benefits to registering. Let your clients know if they're dealing in copyrighted works. Who's the owner of the copyright? This is a very important issue, and this is where we start getting to an area of copyright, federal copyright law, that decouples and disconnects from your normal legal principles that you understand. The first principle is the author is the owner, and ownership vests in the author. So you're doodling, you're the author, you own it. Work for hire doctrine is a little bit different. Works created by employees within the course and scope of their employment belong to the employer. That means the employer is the author. So if you are hired as an employee and your job is to create doodles, you're not the author of the doodles. The company you work for is the author of the doodles. But you have to beware independent contractor agreements, and this is where there's massive disconnect. So, like many businesses, maybe your business is small, they don't have W-2 employees on payroll with payroll tax and all that, and they outsource a lot of their work to independent contractors. And maybe they go out and hire the independent contractor to put together the marketing materials that they're going to use to do the business. And you pay the independent contractor money. You tell the independent contractor what it is to create. The independent contractor creates it for you, gives it to you, you give them the money. You would think that you own all right, title, and interest to that work product, including the copyright. You would be wrong. And this is where the law of intellectual property is very different to the law of real property. For example, in the real property world, if you pay someone to build a fence around your property, you give them the money, they're an independent contractor, they build and design and figure out how to make the fence, and they build that fence. When they leave, they don't own the fence, and no one would think they ever do own the fence. You own the fence, 100%, lock, stock, and barrel. This is not true in the example of you hiring someone to design the fence for you and paying them as an independent contractor. They give you the design and you use it. You don't own the copyright in that design, and that is because under federal law, the author owns the copyright unless they're an employee or unless they assign it. And so this is where many businesses run into trouble. They do a lot of work with independent contractors, they get the work product, from the independent contractor, but they don't get a proper assignment of the copyright in that independent contractor agreement. And if they don't, technically they don't own the copyright. This may or may not matter, but often it matters heavily. And I'll give you an example. Let's look at the next slide. These are the factors courts look at to figure out if someone is a W-2 employee, an employee, in other words, under the Federal Copyright Code, or an independent contractor. And you can see the list of factors. They're very similar, but not identical to the factors courts use for purposes of federal and state taxation requirements. This analysis can be critically important to figure out whether someone was an employee or an independent contractor when they created the work. And here's where it becomes a problem. I've litigated this case, and I've seen this case repeatedly. Represent a small business, it's a small software company, it's startup, it's small, they don't have much money, they can't afford to hire a whole bunch of on-site, full-time W-2 employee programmers, so they outsource the coding to people. And they're a small business. They just pay the person does the coding, and they all run along and everyone's happy. They've got the code, they're out licensing the software, no big deal, right? And they certainly have the right to license the software. The independent contractor is at a minimum giving a license to use the code that he's being paid to create. But a few years go by and all of a sudden the software company's worth a lot of money. And now all of a sudden someone's buying it for $40, $50 million. And the lawyers come in to do due diligence for the buyer, and they want to make sure that the seller owns all the intellectual property. So they want to see the employment agreements, who built the code, who made the software, and lo and behold, they find that a lot of the software was developed by independent contractors. What happens at the same time this process is unfolding is the independent contract software developer hears about the $50 million too, and they jump up and say, I own the copyright. I created the code. I never assigned the code. That's my code. If that company is being sold for $50 million, I want my share. And you are in the United States District Court in a federal copyright case analyzing these factors where you may well lose and have to pay a significant amount of money to that person who you've already paid to develop the code to buy your piece and to be able to sell your company. This happens all the time, and it can be easily fixed on the front end with proper language and agreements, but it's all too often missed because people, general practitioners, often don't realize that there are significant copyright issues that are different to the normal principles that you're used to. And it's certainly counterintuitive. It doesn't really make any sense, but it's the nature of federal copyright law. So let's get back to what are your rights in that copyright. Your doodle, for example, the guitar riff, or the code that you are getting the assignment of the copyright from the independent contractor on now. What are your rights? Well, the right to copy, of course, is the first right. It's the name of what copyright is, and that's the right to reproduce. But let's look at the other rights. You have the right to transform or adapt the work. That is to create derivative works. So think, for example, the original Broadway play Grease. The author of the screenplay had a copyright in that screenplay. That gave the author the right to create derivative works. A derivative work would be the famous John Travolta and Olivia Newton-John movie from the 1970s. That was a derivative work based upon the screenplay. That right to create the derivative work belongs to the original author. The right to make public distributions of the copyrighted work. The right to do public performances of the work. The right to publicly display it. And in limited circumstances, the United States has some limited version of what is known as moral rights, which generally exists in continental European countries. And this is specific additional protections to certain kinds of art under the Visual Artists' Rights Act, which treat the art created as almost an extension of the person themselves with a different flavor in terms of copyright. And that's the European model, which is a little different to the US model, which tends to be more utilitarian. But there are some limited moral rights for specific forms of art. So you have your copyright. The next slide shows what's the infringement cause of action. In general, it's the following. Actual copying, not including true independent creation, of course, and that's shown by access and probative similarity. The second form is that there must be substantial similarity. Now, the first one's very important. There's a famous case that you can think of that's been litigated that addresses this, and that's a famous case involving George Harrison of the Beatles. George Harrison was sued based on a song he released in the 1970s for copyright infringement by a musician artist. The artist said, you know, the musical composition and the music in your song, it's highly similar to mine. And it's very, very similar. And there was such substantial similarities that experts looked at the music, concluded, geez, it'd be hard to sort of independently stumble into it. But George Harrison honestly and subjectively explained that, no, I literally did not copy your music. I'd never heard your music. I just independently created this. So the plaintiff in that case showed evidence that at the time the plaintiff had released its song, many years earlier, it had received a lot of public airway play on the radio in certain areas in the country, and showed that at the same time, George Harrison was touring in those areas of the country. So in high likelihood had been exposed to the music and probably heard it. And the ultimate conclusion that that case came down to, that proved, was that George Harrison honestly didn't think he copied the music. But the conclusion was he had had access to it, he had heard it, and it probably simply became part of the backdrop of his mind and his musical thinking. And when he drew on it years later, he may have genuinely thought that he independently created it, but he had really borrowed from something he was already familiar with. That's an example of how you prove access to and copying even when someone genuinely believes they independently created the work. Now, fair use. This is something that everyone knows, right? Fair use. If it's for an educational purpose, I get to use it fair use. Another myth in copyright law. So, fair use is a codified defense under U.S. federal law in the code, and here are the 4 factors that courts look at. The purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion that's used in relation to the copyrighted work as a whole, and the effect of the use upon the market for the copyrighted work. What's the first thing that leaps out at you on those 4 factors? It's mushy, it's gray. Lawyers on each side of that can argue those all day long, and they do argue it all day long. We do argue it all day long. So the basic reality that you need to be aware of when it comes to fair use is that it's very hard to sit down with a client and tell them, oh yes, that material you've created, your marketing material, your screenplay, whatever it is that your client may have created. You look at it, you compare it to something else, and they're similar. It's very difficult for you to say, yeah, but don't worry, you have fair use because you meet these 4 factors. Those 4 factors are mushy and they can go either way. And so fair use law has become an area of law that makes it very hard to have certainty on the front end that you are safe in your copyrighted work. So you definitely want to consult with a copyright lawyer to see if you would be able to take advantage of the fair use defense. The next slide shows uses that generally are deemed fair ones. And so criticism, for example, quoting a work in a review for purposes of illustration, that's a fair use even though you're taking part of the original work and reproducing it in quotes. News, for example, summarizing news stories or articles that have limited reproductions of the specific words out of those news articles, that's generally a fair use. Research that you quote in scholarly scientific type journals, that's a fair use. Non-profit educational uses, for example, some photocopying for classroom use, that can be fair, but here's where there's a massive myth in the realm of non-IP lawyers. Education does not equal fair use. So just because you're using it for your students or you have some person who's starting some sort of non-profit educational business to help out students, everything they copy doesn't transform into an educational fair use purpose. And many educational institutions have been sued for copyright infringement. They've asserted, wait a second, we're making course packs for students. It's a fair use. It's for knowledge and for learning and for their advantage. And courts have held that is not necessarily fair use and they have to pay. So the caution here, be very, very, very careful. Parody is generally deemed a fair use, and that's a work that humorously mocks the original work. But you have to be careful. There's a very fine line between what is parodical, humorously mocking the original, and satirical. And satire is not fair use. And here's an example of a case that my firm litigated, a very significant case on this line between satire and parody. We represented a U.S. Senate candidate who was running for the Senate and took a liking to a Don Henley song, The Boys of Summer, and so created a sort of campaign video based on the Don Henley song that the Senate candidate was using to make some sort of a political statement and was sort of mocking the policies of the opposition party. And so this video was made, it was a YouTube video, and no offense to our client, the Senate candidate, but he didn't have a good voice. And so he certainly wasn't causing people to not buy the Don Henley song because they wanted to listen to his version on YouTube, his sort of screeching cat version, right? So you may think that, and it was for political purposes, and it was sort of making fun of sort of, of political issues, that this was parody. But it turned out, given the nuanced nature of parody and satire, that the district court disagreed with us and concluded that Don Henley had a copyright infringement claim because the song was not parodical. It wasn't humorously mocking the Don Henley song. It was satirical. It was being used to criticize and point out something external to the song in society about sort of the nature of national politics. That kind of a use didn't guarantee a fair use defense, which means there's a lot of uncertainty for the Senate candidate litigating the case. So again, massive uncertainty in terms of fair use. You must beware. So here, the next slide shows some issue spotting that's relevant for you in your practice, for your clients. Do any of your clients have any created content or expression of any kind? If so, they may have copyright issues they should protect. Have they borrowed from the internet? If they have, it's a big no-no. The internet makes it very, very easy to infringe other people's works. Just because you find something on the internet doesn't make it public domain or free. Even if it says it is, it doesn't make it public domain or free. You need to make sure you have clearances on the work. Have your clients created software, code, apps of any kind? If they have, they're trafficking in copyrighted works, and more often than not, they're paying independent contractors, which means you want to make sure they have proper agreements getting copyright assignments so that it's clear they own the copyright. This gets back to your employee agreements. Even if you have straight up employees, you want to make sure for copyright purposes that it's very, very clear that the works they're creating belong to the company. That gets us from copyright to trademark. Now, copyright, of course, was governed exclusively by federal law. Trademark is governed by federal law, but it's a dual regime. Trademark law doesn't preempt state law, so you have state trademark laws too. So let's first of all talk about what is a trademark. Well, the common synonym for trademark is your brand name. So the examples you see on the slide are Coke, 7-Up, Google. Those are trademarks. They're the brand name of the business that connotes a source or an identifier of the company and business that stands behind that logo or brand. What can be trademarks? Well, words and logos, of course, but also numbers, shapes, sounds, smells even. Sounds, yes. Ferrari has a registered trademark on the sound of that Ferrari engine. You know that incredible roar you hear when you're driving down the road and you turn your neck because you hear it and boom, goes by a Ferrari. That sound, Ferrari has a trademark on, which means Lamborghini, McLaren, Bentley, and all these other high-end cars, as they tune their engines and the exhausts to make their loud sound, they need to be careful that it's not identical to the Ferrari sound. The Ferrari sound is unique, it turns out. You may not have known that, now you know. So, a trademark must connote a given company's goods or services. It has to be a source identifier. So that logo, that Ferrari sound has to connote, you hear the sound, you think Ferrari, Google, Google. When it's applicable to goods, it's known as a trademark, and when it's applicable to a service, it's known as a service mark, technically. So you can think of, for example, Saks for clothing. It's a clothing store providing that service. Or One LLP, my law firm, it's a service mark. Trademarks have even extended to product packaging, so maybe the design and packaging of a product, like your Coca-Cola bottle, for example, elements of that can be trademark, trade protected. Even the non-functional features of an actual product configuration can secure trademark protection. So famous designer chairs, for example, can secure trademark protection. This next slide is on trademark law focus. This is the focus of trademark law. Number one, you want to identify the origin of this article in commerce. It serves as, number two, quality assurance to the consuming public that that product is associated with a brand. Now, as you can already see, the heavy focus on trademark law then is in protecting consumers and avoiding consumer confusion as to who is delivering the good. And this is a very, very important aspect to trademark law. The third one, and this is a general point that's important, is that it's a symbol of goodwill. It's your sort of commercial magnetism. So the word Google connotes certain things. The Nike swoosh connotes certain things. It's the commercial magnetism of the company. And if another company were to use a swoosh when they were not Nike, they would be stealing and appropriating to themselves that commercial magnetism that Nike has built up with its swoosh logo. Practical pointers for your clients. The use of quote-unquote TM and then the little R with a circle in it. TM is used when you have common law trademark rights, and this immediately gets to a very, very important point. Like copyright law, you do not have to register with the federal government to have a trademark. Copyright law, you had a copyright at the moment of creation. There were benefits to registration, as you remember. Trademark law is sort of analogous. Trademark rights exist at the moment you use in commerce your logo or brand. So, if I come up with a nifty little logo today for my law firm and I put it on the website and that's the logo I start using for my law firm, I have trademark rights today. And I have the right to put TM next to it to let the world know that that's my common law trademark right. And those rights start accruing based on your use in commerce of the trademark. Now, the little R with a circle around it is used once you have received and issued federal trademark registration from the U.S. Patent and Trademark Office. Why would you register a trademark, you ask? Well, it's very similar to why you would register a copyright. There are huge benefits to doing so. Number one, when you register your federal trademark and you get your federal trademark from the government, you now have a national footprint on your brand. So, we're going to use an example here to give you a sense of what I'm talking about. Let's say you have a client who's starting a new fast food chicken restaurant, and they want to call themselves Kudos Chicken. And they only have one little store in Los Angeles, and that's all they have right now. They don't have a lot of money. Who knows if they're ever going to expand, right? The moment they start using Kudos Chicken in Los Angeles, they're developing common law rights based on their use in commerce. But the benefit to registering is if they get a federal registration on Kudos Chicken, they now own a national footprint, basically, which means if someone comes along and opens a Kudos Chicken restaurant in New York, your client in LA gets to go to the New York company and say, you got to change your name. I own a federal registration. You're not allowed to come into New York and open a restaurant using that mark. And the New York company says, well, hold on, you're only in LA, you're not even going to come to New York. And the LA company says, too bad. I may go one day, I may not go one day. You're not allowed to use it. That's a massive, massive benefit to getting a federal registration. If you don't get a federal registration, even though you were first in LA using Kudos Chicken, and someone comes along in New York and opens a Kudos Chicken chain, if you've never been to New York and you've only advertised and sold chicken to customers in LA, you can't stop that company in New York from opening a chicken chain called Kudos Chicken, because there's going to be no likelihood of consumer confusion ultimately, because you're in such drastically different markets. So there's a massive benefit to registering. The second aspect to this is that registering doesn't necessarily guarantee you rights no matter what. So let's stick with our example. Your client opens a Kudos Chicken in LA, they're chugging along, they get a federal registration, and let's say the government issues the federal registration. Now you have a federal trademark, and you have your Kudos Chicken store. And you decide one day, we're gonna go from LA to Memphis, Tennessee. And you go to Memphis and you open a Kudos Chicken restaurant in Memphis, and you've got your federal trademark. And lo and behold, you get a letter from some lawyer in Memphis who says, what are you doing? I have a client with Kudos Chicken in Memphis. We've been here for 20 years. You turn around and say, well, I have a federal trademark and you don't. And the lawyer in Memphis says, doesn't matter, I don't care. And he's right. The existence of a federal trademark does not trump senior common law rights that may exist out there. This is critically important. This is another reason why it's important to get a federal trademark, because the act of getting a federal trademark requires a lot of research into marks that are being used out there in commerce, and hopefully in doing the research you would have found out about this Memphis, Tennessee company. Even if you haven't, you still have your federal registration, and so you can still go all over the country, and that Memphis, Tennessee company can stop you going into Memphis for sure. They have senior law, common law rights there. But if they want to move to Seattle, they will not be able to, even though they were using it first historically. So, huge benefits to registering federally a trademark. The next slide. These are sort of the categories of marks, so to speak, that are out there. The first one is generic, descriptive, and then suggestive and arbitrary. I'm going to talk about each of them. Generic. Well, what generic means is it's the common term for a product used by many. And if you use a generic name or mark, so to speak, it's not a mark. Trademark law will not give you protection over generic marks. And so here are some examples. You want to talk about consumer electronics. Well, consumer electronics is just a general description of the product that's used by many. I want to call my law firm an intellectual property law firm. That is a common term just for any firm doing intellectual property law. You cannot monopolize that term under trademark law. There will be no trademark protection. This is important for your clients who are starting businesses. Maybe they want to get going, and the first thought is to come up with something that's very generic like that because it kind of explains exactly what they're doing. They need to be advised, and you should be aware that they may have no rights in that mark, and so it may not be a good mark to invest in, because ultimately if they happen to become super successful, other people will start cribbing the name and there's nothing you can do about it. This gets us to descriptive. Descriptive marks are marks that convey an immediate idea of the qualities, characteristics, ingredients of the good. And so you can get trademark protection for something that's descriptive if you show secondary meaning. And secondary meaning means that the consuming public has come to associate this descriptive mark with you. So here's an example. Honey baked for ham. It's descriptive. The ham is honey baked after all. Vision center for optics clinics. They are centers built around vision. They're vision centers. So they're descriptive. But if enough investment is made such that the consuming public associates vision center with a particular source, then they will have shown secondary meaning and they can have a trademark in that descriptive term. The advice to clients on the front end is, although you have this drive to come up with something that's descriptive so that you can connote to the whole world what it is your business is doing, there's a big danger in it because it takes time to develop secondary meaning and you may not be able to get trademark protection. So the general advice should be, try to avoid even descriptive things. This gets us to where you start having protection, cleanly and fully. The next slide, suggestive marks. A suggestive mark, as the slide shows, echoes some aspect of the product or service, but the connection is not immediate and it requires some imagination, perception to connect it to the product. Sort of a mental leap is made between hearing the mark and tying it into the product, unlike the last example of vision center. You hear vision center, you know it's a vision center. There is no mental process you have to go through. Suggestive marks have immediate rights, and so here's an example. Contact for adhesive paper. You hear contact, you don't instantly think, oh, adhesive paper, of course. But there's a mental step you go through where you go, oh yeah, contact, adhesive paper, it sticks, I get it. That mental process shows that it's suggestive. Another example, Playboy for men's magazines. The word Playboy doesn't instantly connote a men's magazine built around naked women and fashion and whatnot. But there is a mental leap by which you connect, oh yeah, like Playboy, easy lifestyle, all that, and within one or two mental leaps, boom, you could land on a magazine built around that. Q-tips for cotton swabs is another one. So suggestive marks are what you want your clients to go for because they have immediate trademark rights. Now, the highest level of protection is for arbitrary marks. An arbitrary term is simply one that's used in an unfamiliar, arbitrary, as the word says, way. This has immediate trademark rights also. It's the strongest form of a mark. So, example, Camels for cigarettes. There's no amount of mental leaps that you could go through where you would start with the word camel and land on a cigarette. There's just no connection whatsoever between camels and cigarettes. That makes it arbitrary. Another good example, Kodak, Exxon, Rolex, Google. Google and search, there is no amount of connected steps by which you get there. Kodak and photos, it's just a word that's made up for photos. Today we may associate it very quickly with it because they've developed such a good brand, but the word itself is divorced, so it's arbitrary. So the drive always is to avoid being super descriptive, be as suggestive or arbitrary as you can, and that will protect your clients from wading into other people's marks, and it'll also give you a well-demarked property right. Trademark infringement. Kind of like copyright infringement, what's the analysis? Well, this is the analysis. On this next slide, you see the central focus, again, is likelihood of confusion. Is the defendant's acts using a mark that you think is similar to your mark, is it causing confusion in the consuming public? Now, this is a different analysis to copyright. Copyright isn't concerned about whether the copying of your screenplay has confused people. It may never have confused anyone. It may be crystal clear that the person who copied your screenplay has nothing to do with you and no one thinks you're remotely related. It's still copyright infringement. In the trademark realm, there needs to be this consumer confusion that exists because the root of trademark laws is more focused on protecting the consuming public from being duped or deceived into thinking that an article in commerce is associated with a given brand when it's not. That litmus test is different, and it's very, very important. And so that's why courts look at these factors to assess whether there's a likelihood of consumer confusion as between a defendant's use of a mark and your mark. So the first factor is the strength of the mark. This loops back to the basic business advice you're giving your client on the front end. When they're picking a mark, you want a strong mark, because if they have a very weak mark that's descriptive, the courts are going to weigh that in the calculus and say, people are less likely to be confused because you're just using a descriptive term that everyone uses. No one's really confused. So strength of the mark is important. Similarity of use is important. The good faith of the defendant, whether they intended to steal it or whether they're just operating in good faith, is important. And that's a very important factor, and that factor itself becomes harder for a defendant to escape an intent showing when they took something that's really arbitrary. Again, that's why you want to go for arbitrary. Any evidence of actual confusion in the marketplace. Actual confusion helps a lot, but there doesn't have to be actual confusion ultimately, because the legal test under the Federal Lanham Act is whether there's a likelihood of confusion. And so actual confusion can illuminate it, but expert testimony can often show that even absent there being any existing actual confusion, people are likely to be confused because of the nature of the marketing. The sophistication of the market, the purchasers, is an important factor. The more sophisticated and complex the product and the purchasers are, the less likelihood there is to be confusion. So if it's McDonnell Douglas making specialized nuts and bolts that NASA buys for the space shuttle, and a company comes along and makes a similar nut and bolt and tries to sell it to NASA, NASA is highly sophisticated. It's going to be very hard to show a real likelihood of confusion by NASA into thinking that this nut and bolt for the space shuttle is really associated with McDonnell Douglas when it's not. And then the quality differential on the products, of course, illuminates part of whether there's likely to be any confusion. Fair use. We have trademark fair use just like we have copyright fair use, and it has similar First Amendment underpinnings just like copyright. Here's the principle of trademark fair use as you see on the slide. A competitor can use another's mark in a non-trademark sense to generally mention or discuss the product in comparative advertising. So here's an example. You are Coca-Cola and you want to do a commercial that shows how long Diet Coke stays fizzy when it's poured out of the can compared to Diet Pepsi. And so you say, here's Diet Pepsi in the commercial, you pour it in a can, you pour your Diet Coke, and then you show that the Diet Pepsi is not fizzy as long. In that commercial, you've shown the Diet Pepsi logo and the brand on the can. You've used that trademark in your commercial. And so the question is, have you infringed Diet Pepsi's trademark? And the answer is no, you haven't. Coca-Cola has the right to, in order to do comparative advertising, show that trademark. Coca-Cola is not, by showing the trademark, indicating to the public that Coca-Cola is affiliated with or sponsored by Diet Pepsi, of course. So that's an example of trademark fair use, where Coke can use the logo in a fair use manner. This quote comes from a case. The fair use defense forbids a trademark registrant to appropriate a descriptive term for his exclusive use, and so as to prevent others from accurately describing a characteristic of their good. So, for example, if someone wants to say, I don't like, blank business. That is their opinion. They have the right to say, I don't like blank business, and that's not violating blank's trademark. Let's get more concrete. I think Nike shoes are not as good as Adidas. Nike may not be happy that I just said that. I used the Nike mark in my statement. That is a non-trademark fair use. Nike doesn't get to monopolize the word to the exclusion of people like me or anyone's right to discuss that product that the mark stands behind. And the fair use defense, of course, it allows a junior user, that's someone who is late coming into the market, to use a descriptive term in good faith in its descriptive sense other than as a trademark. And that's another way of saying the same thing. If you're new to the trade, new to the shoe business, for example, and you want to say my shoes are lighter than Nike's shoes, you get to do that. So the next slide is, like with the copyright, the issue spotting for you as a general practitioner. Well, people come to you all the time and they want to start businesses, or they have businesses and may not realize that their mark has real value. Maybe their mark's being infringed and you could unlock value from the infringer who shouldn't be using it. So Number one, you want to use caution in selecting a proper name for the business on day one. This is where the most basic mistake is made all the time. People don't want to really spend money on a trademark lawyer and do a trademark search. They just want to get their business going, and they do a pretty good job. The business gets going, and all of a sudden, having invested some real sweat equity and some money, they get a letter from someone and they have to change their name, which is a disaster for a business on the front end. Here's the reality. If it's worth starting a business, it's worth paying a couple $1,000s to a trademark lawyer to make sure you get a name that's protected and safe, to make sure you don't have to face those business uncertainties down the road. Number two, anytime you have clients creating new product or service lines within their business, there's trademark issues that are alive. For example, maybe you have a client that's in the garage door business and now they want to start selling windows. Well, the window space is crowded. There's a lot of companies out there in the window space. And your client comes up with a new logo for its windows, it needs to check to make sure that that logo now being used on this new product offering isn't running afoul of someone else's rights. Number three, you really want to secure registration. Just like with copyrights, there's a real value in registering for all those discussed benefits I talked about earlier. It's relatively inexpensive to register a trademark. It's a useful process to help illuminate your even right to use the name that you're using, and you get that national footprint that you want. And remember, all of this ultimately comes back because deeper protection, whether it's copyright, trademarks, and we're going to talk momentarily about patents and trade secrets, all of this creates more business value for your clients. And what happens routinely in acquisition scenarios, once the business has been built up, the buyer wants to understand, well, what kind of rights do I have to keep other people out of this marketplace? That's the value I'm buying, the premium I'm paying in the purchase price, of course. And that's often a function almost entirely of intellectual property and what kind of IP rights are there and how strong those IP rights are. So registration helps you there. This gets us to patents. And there's been a lot in the press in the last few years about patents. So what are patents for? They're for new inventions or new ways of doing things. Patents, unlike copyrights and trademarks, have a mandatory registration application process. You have to apply for a patent and you have to get it issued in order to have a patent. Absent the US government giving you a patent, you don't have a patent in the United States. It's not a dual regime like trademark law where the federal government can give you trademarks, but you can also get state trademarks. It's exclusively a federal regime, just like copyright was exclusively a federal regime. Patents apply, as you see on this slide, to new, useful, non-obvious inventions. That's sort of the trifecta. It's got to be new, useful, non-obvious. So what kinds of things that your clients are doing may trigger patents? Well, some are the obvious. They're making inventions of products and devices that everyone kind of at a rudimentary level thinks a patent is associated with. But patents are broader than that. Patents are associated with methods and business methods and processes of doing things. Software processes can also be covered by patents. That's less intuitive and less obvious, and that's also provoked a lot of significant controversy in the last 10, 15 years in the litigation system over the viability of those patents. Patents also cover designs, and so a subset of utility patent law is design patent law. So you can get design patents on the specific incantation of your design. So maybe you have a new, incredibly beautiful candle holder that's very, very unique and specialized. You can get a design patent that protects the ornamental, non-functional aspects of that product. So there you have something that the average intuitive lawyer who's had real property as a first-year law student, but not intellectual property, would think, it's a candle holder. You obviously can't get a patent on a candle holder. I mean, candle holders have been around since the ancient Romans, all of which is true. But your client's unique candle holder could get design patent protection, even though candle holders have been around since the time of the ancient Romans. The key fact here, though, is that you have to seek patent protection within a year of any public showing. This is very, very important, and this ends up tripping up many would-be patent owners. And so let me give you an example from a patent case my law firm has taken for one of our clients that we've tried in trial. We had a client who made crosswalk sort of software and devices to help disabled people when they're crossing the streets. And so you're at a major intersection, you need to have a proper system that can alert the visually impaired of when they can cross streets and whatnot. So our client has applied for a patent. Now, before our client got the patent, they tested their device. And the only way you could test something as big and cumbersome as that is to actually go out into the public world, and test it. And so they went into the public and they put it in an intersection to test it. That public testing was done. Now, that public testing did not invalidate the patent. It was done. You're allowed to do that kind of testing. And so they filed their patent application and they were okay. Now, take another example, of course. Let's say you've come up with a great new airplane and you fly this airplane around, you show it to the world, you're using it. And more than a year goes by, you want to go get a patent, you're out of luck. So the general advice you need to give to your clients is as follows. If you're working on something that could be subject to a patent, keep it secret, don't publicly show it, and apply for a patent application immediately. Speak to a patent lawyer, get a patent application on file so that you have your foot in the door, so to speak, and you're protected against anyone coming back to challenge you later as having publicly displayed it prematurely. The next slide shows the patent cause of action. Now, of course, you have to get a patent from the Patent Trademark Office, and once you do, you get your patent and it lives for 20 years. What's the analysis, though? You get this patent. It's a long, complicated document. It's got all these pages of technical jargon that are explaining the industry, the technology, your invention, the background, other inventions, what's out there. And there's this long, complicated document that your patent lawyers will create. The culmination of that document is what's called the claims of the patent. And as many a judge and a lawyer has said, the name of the game is the claim in patent litigation. And the claims are the specific language that sits at the end of your patent that explains exactly what it is you're claiming as your invention. And that claim language gets worked out during the process of patent prosecution. And it gets worked out because you apply for your patent and the patent examiner looks at it and finds lots of prior art that's out there and other inventions and says you can't have that. And so there's this process that morphs and narrows and changes and alters the language of your claims. And they're ultimately settled upon a very specific set of language. Once that language exists, if someone infringes your patent, it's because the exact language in your claims is found in their product. Your claims read on their product perfectly, and you find then literal infringement. That's the nature of the infringement analysis. So as you can see, that's a very different analysis to the trademark analysis that was looking at a whole, balancing set of multiple different factors to figure out whether there's trademark infringement. It's different even to the copyright analysis we talked about that was looking for substantial similarity. Copyright doesn't require kind of one-to-one similarity. It can be substantial and still infringe. Patent needs literal infringement. So your claims are very, very important. And so that act of getting the claims itself is something that clients need to do with lawyers, because if they go on their own and get it, they may get a patent issued, but the claims may ultimately be useless. Lawyers skilled in getting patents are aware of how those patents can be used in litigation down the road, and they know how to get the right or the best claim language possible for your invention. Now, if all the elements of the claims are present, then there's infringement. But even if one of them is missing, there's still a doctrine called the doctrine of equivalence that gives you a little bit of breathing room. Not much breathing room, not as much as copyright substantial similarity, but a little breathing room. The defendant has many defenses. The issuance of a patent doesn't simply mean that no matter what, if someone infringes, you prevail. The defendant gets to show by their research that there's prior art out there, even maybe other patents that the patent office already considered. They get to show to the jury and the judge, if there's prior art out there that invalidates your patent, you lose your patent. They get to show that your invention, even though the government issued the invention, even though an examiner issued the invention, if it's obvious to one skilled in the art and a judge or a jury concludes that as a matter of law or fact at trial, then your patent's invalidated, notwithstanding the issuance of it from the government. And if you engaged in any fraud, essentially, during the patent prosecution process, what's called inequitable conduct, you can lose your patent. And that occurs when you're seeking a patent and you don't disclose candidly to the patent office all the different art that you're aware of in the industry. And you would be stunned, but years later in litigation, routinely we find pieces of paper in the plaintiff's files that show they had artwork that wasn't, or patents that weren't given to the patent office, or they were aware of flyers from other competitors that weren't given to the patent office. And you dig those things up in litigation and they become often smoking guns showing that material was withheld from the patent office. And that's a serious charge and it invalidates your patent. The final area we're now shifting to is trade secrets, and this is sort of the fourth leg of our chair, so to speak, of intellectual property. And as of 2016, trade secrets is subject to federal law. Until 2016, it was only a creature of state law under the Uniform Trade Secret Act, adopted in all states essentially. Now, the federal law, Congress has codified a federal trade secret statute. So we now have a dual regime. There's state trade secret law and federal trade secret law. Trade secret law is incredibly important because it gets your client, if their trade secrets are taken, enhanced damages for willful thefts, as well as a very broad and just enrichment remedy. There's absolutely no registration requirement of any kind. You don't have to go to a government office and say, here's my trade secret, and get it stamped and registered. Your secrets, such as the formula to Diet Coke, for example, if someone stole the formula to Diet Coke and made a competing Coke product, that trade secret won't be exposed in litigation. There's protective orders and legal elements in place to protect the secrecy of your trade secret in litigation so that there's no downside to you seeking protection. And also under the new federal law, there's extraterritorial effect to U.S. defendants' foreign activities. So if a U.S. defendant abroad steals your trade secret and does something, you can get a remedy here in the United States even though the theft occurred abroad. What's a trade secret? This is our next slide. And you can see the root of it is any and all kinds of financial, business, scientific, technical, economic, engineering information. Patterns, plans, formulas, designs, prototypes, methods, techniques, processes, procedures, programs. Very, very broad, as you can see. This, as you can instantly see, touches on all sorts of activities of any average business, whatever it's doing. If it's a dog walking business and it's figured out how to walk dogs better or get clients better, that internal know-how is a trade secret. You only get protection, though, if you've taken reasonable measures to protect it. This is the bolded language here. This is where it becomes critical to give clients good advice on the front end. What's a reasonable measure to protect your trade secrets? Well, you better act as if it's a trade secret on day one, and if you don't, courts later on aren't going to think it's a trade secret. So if you have a great dog walking business and you've figured out how to get the best clients in town to walk their dogs, and you have a special marketing sauce that no one else has or a client list, you need to password protect it. If you hire other dog walkers to walk for your business, they need to be signing employment agreements that are making clear that you have trade secrets and they're confidential. Those are the types of DNA that you can then point to down the road to show the court, to be able to say, Your Honor, look, I did everything I could. I treated it like a secret. It's a secret. So our next slide for trade secrets under our new Federal Defend Trade Secrets Act details the cause of action for trade secret misappropriation. So this is what it says. Any disclosure or theft by a person acquiring a trade secret who knows or has reason to know that the trade secret was acquired by improper means, or the trade secret is disclosed or used without express or implied consent by a person. Let's just stop there. A person who knows or has reason to know. This is why you want your employees to be signing agreements when they start working for your client's company that recognize that the employer has trade secrets. Because then if the employee leaves to start a competing business down the road and takes some of that material, you have some evidence that you can point to that shows that that employee knew or had reason to know that there were trade secrets afoot. Now, if those people know or have reason to know, or they secure it without consent, or they use improper means to acquire the trade secret, at the time of disclosure, or used, knew, or had reason to know that the knowledge of the trade secret was derived from a person who had used improper means to get it. This now broadens the net. The common scenario that we see all the time in litigation is your client has a business, they're running it, it's pretty successful, and their employees leave to start a competing business. And everyone has the right to compete. No one gets to monopolize dog walking, if we stick with that example. Employees of a dog walking business have every right to start their own dog walking business, but they can't steal the secrets of your dog walking business to start it. And if they partner up with a completely independent third party, and that third party says, hey, go get the client list so we can go underbid the clients to get the dog walking business, that third party has been a person who used improper means to get someone to solicit a trade secret. Continuing on, if it's acquired under circumstances giving rise to a duty to maintain the secrecy or limit the use of the trade secret, this of course deals with implied confidential relationships in scenarios where, for example, maybe you're going and pitching a new idea to someone and you say, hey, I've got this great idea. If you're in the business, let me pitch it. Maybe you don't have a formal written NDA, but you have a discussion and the person says, yeah, I understand, I'll keep it confidential, and if it's a good idea, we'll jointly exploit it. And so that, at that point in time, imparts upon the person who's receiving the trade secret a duty to maintain it in confidential relations and understand that if it's to be exploited, it's to be exploited jointly. This comes up all the time. This comes up, in small businesses, in solos who are getting ready to start in business. This comes up in the entertainment industry. It comes up in any new product development phase where people have ideas. Anytime ideas are being pitched or discussed, you're sliding into trade secret territory. And finally, that this trade secret was a trade secret, a knowledge of the trade secret was acquired by accident or mistake. Those are the sort of exemplary ones on the outside. Now, under federal law, there's a unique quirk, and this has required companies that have employment manuals and employee agreements to go back and revisit those agreements and add some language. If you want to go into federal court to take advantage of the federal trade secret statute, and there are many benefits to being in federal court instead of state court in certain circumstances. And one of the federal court benefits is that you can get enhanced damages, of course. And so if you want to get that benefit, you have to put in your employee agreement certain notices of immunity that apply to employees. What does all this mean? Well, under federal law, your employees are immune from trade secret misappropriation if they happen in confidence to disclose a trade secret to an attorney or a government official for the purposes of reporting or investigating suspected violations of law. So for example, you're whistleblowers. If an employee is ever a whistleblower, they have immunity if in the act of whistleblowing and shedding light on the corporate fraud, they happen to disclose a trade secret, they're entitled to immunity for that act. You as the employer need to let them know that they have that immunity. And if you do not let them know they have the immunity, if your trade secret's misappropriated by that person in some means, you are not entitled to some of the enhanced remedies that you would want. That would then mean you may not be able to be in federal court because of the disadvantageous remedies, and you may need to be in state court. And depending upon your jurisdiction, there may be great downside to litigating a case like this in state court instead of federal court. One of the things that's critical here then, that I hope you've seen by now, is that intellectual property cuts through all areas of law. If you are a family and trusts and estate lawyer and you're sitting here thinking intellectual property has nothing to do with you, you now realize it really does. Your clients may have created copyrights. Those are assets that they could descend to their heirs. There's ways of monetizing those assets. Your clients may have businesses. The business may be dissolving. If you're a corporate lawyer and you're dealing with this dissolution, you have to figure out who has the trademark. Where's the trademark going? Is it federally registered? If you're a criminal lawyer, all of these areas of law touch you. Theft and misappropriation of intellectual property has become a massive area of criminal focus and criminal concern in the last 10, 20 years, especially in the last 5, 10 years, because of the massive advent of the value of intellectual property in litigation into businesses. So trade secrets often trigger companion federal criminal investigations or state criminal investigations. Copyright misappropriation often is sort of a criminal violation that gets triggered and is a tool in criminal law. You need to understand these basic aspects of what it is, what property is at issue that's being appropriated to even know if it's even a viable federal claim that could exist. So it cuts through all areas of law. Here's the bottom line that we've seen. All 4 areas of law, of intellectual property law that we've discussed, are federally regulated. Some have dual regimes. The existence of intellectual property assets is often misunderstood and overlooked. Some of the principles are not intuitive to your normal tort contract principles, so you need to be aware of federal IP law. The basic legal assumptions you make are not always correct, that is. Some of these areas of law have formal mandatory registration requirements, patent. Some do not, trademark, copyright. But even the ones that do not, trademark, copyright, Huge benefits in registering. You want to get a lawyer doing it. It's relatively cheap and inexpensive, and it can pay huge dividends down the road to your client's business. Finally, your client's employment agreements or independent contractor agreements. They need to be reviewed and analyzed to make sure they comply with federal copyright law dictates, as we discussed about earlier, because otherwise your client may be giving up an asset it doesn't have to give up. Thank you very much for listening to this continuing education program, and I look forward to any questions, comments, or emails. I'm happy to answer them at any time.